Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Where the heck am I today? Well, I am up in the VIP lounge right now of Guns and Gear right here in Idaho Falls, Idaho. Now listen, if you're near the Idaho Falls area and you haven't stopped by and checked out all the cool things they got going on here at Guns and Gear, we're going to put all of their information down below in the description box. Absolutely the top FFL anywhere in the state of Idaho. Come by and check them out. America, we need to talk about forced reset triggers. Why? I know a lot of you are like, why are you talking about that? You've been talking about the pistol brace rule. I thought that was dead. I thought the thing on the forced reset triggers was pretty much dead also. Yeah, that's what we thought until a bunch of attorneys general decided that they needed to get involved because, well, they have no faith in the incoming presidential administration. I'm actually not making that up. Now, we're going to go through their memorandum trying to intervene in this matter, and then we're going to let you know that the Fifth Circuit, well, they didn't really want to have anything to do with it. So today, from Idaho Falls, let's talk about this is how they're going to interfere with President Trump's gun agenda. Okay, America, the case we're talking about today is National Association for Gun Rights v. Garland. This started off as a challenge in the United States District Court for the Northern District of Texas. It has now proceeded to the Fifth Circuit. This is a challenge to ATF's sudden and abrupt determination that forced reset triggers standing alone constituted unlawful machine guns. Now, as you know, the trial court was having nothing of it and permanently enjoined ATF's rulemaking order. The United States government appealed to the Fifth Circuit. Good luck with that. And oral arguments took place last month. We do not have a ruling on that. However, today, January 16th, 2025, it appears that there are several state attorneys general who believe that they now need to intervene. And just so you understand what states have decided that they now need to butt their nose into it, they include New Jersey, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, Michigan, Minnesota, Nevada, North Carolina, Oregon, Rhode Island, Vermont, and the People's Republic of Washington. Now, understand that even though the Department of Justice was representing the ATF in this determination, all of these attorneys general now believe that they need to step in and they need to represent the ATF and this rulemaking order. Why is that? Well, that's going to be one of the most offensive things of this memorandum. But I want you to know that as I was preparing to shoot this video, got a message from Miss Hannah Hill over at the National Association for Gun Rights, and we have found out that the Fifth Circuit, in a very terse order, has denied this motion already. So I want you to understand that this motion has been denied. But the title of this is how they're trying to undermine President Trump's gun agenda. And I want you to take a look at what these attorney generals were willing to offer as support as to why they should have been allowed to intervene into this matter. The main reason by which all of these states believe that their intervention into this action was necessary was movement states' interests are no longer adequately represented, and movement states swiftly intervened in light of that change. What are they talking about? Because of the incoming administration's views will likely diverge from those of the current administration on firearms policy matters, existing parties no longer adequately represent movement states' interests. The movement need only show that representation of his interests may be inadequate, not that it is certain. Okay, so I want you to understand, America, what these attorney generals are arguing is that because there's going to be a change in the presidential administration, a change at the Department of Justice, a change at the ATF, that gun control is not going to be feverishly pursued anymore, unconstitutional rulemaking orders are not going to be proffered anymore, that the states need to intervene to make sure that these activities survive. And what the states are actually asking is an opportunity for them to come in and fight in support of federal law, despite the fact that many of these states who joined in on this memorandum actually have state laws that ban not only forced reset triggers, but bump stocks and a lot of other rapid fire devices. So do the moving states here need to at least demonstrate something beyond they have a desire to be involved? Well, technically, yes, they do need to demonstrate that not allowing them to intervene would create substantial prejudice to them. So what arguments do they make here? Movement states would suffer prejudice if intervention is denied. Movement states maintain proprietary and quasi-sovereign interests, which would be heightened by a future administration's decision to abandon any defense on the merits. How is it that states could be irreparably harmed when many of these states have the exact same laws in place? And oh, by the way, if they didn't, Couldn't they just pass some? Well, that appears to be prejudicial according to the moving states as well. And by the way, what exact evidence do these states offer that suggests that this administration is not going to pursue the forced reset trigger in the same way that the previous administration did? Well, it's in this line right here in the memorandum. That concern is heightened here. While federal defendants have represented movement states' interests, the president-elect has expressed opposition to firearm restrictions and to the Biden administration's ATF actions specifically. And then, of course, the site for that, oh yeah, that's a CBS News story from November. So, take that for what it's worth. But apparently, according to these attorney general, we need to be relying upon what CBS News is telling us now. Now, we say here all the time that, they're going to pass these gun laws, but they know it's not going to actually affect anything. Well, some of these states acknowledge, hey, we already got statutes that ban the use of forced reset triggers. Why is that not sufficient? Well, according to them, an order that prohibits ATF from taking enforcement actions to prevent dissemination of FRTs, let alone a court order as below that enjoins prosecutions and mandates their return to dealers and possessors, would dramatically expand the proliferation of FRTs into movement states. Even in states where FRTs or FRT-equipped firearms are unlawful, their spread, absent federal regulation, is inevitable. So are you saying that any state law that bans anything of a firearm nature is really ineffective unless there is a companion piece of federal legislation? Because that's what the attorney generals are arguing here. They also argued that there would be increased legal costs, not only in prosecuting individuals for possession of FRTs, but some of these states are going to have to go back to the legislative drawing board and actually pass FRT restrictions, which of course has a cost to it. They believe that that equates to prejudice. But at the end of the day, as I was preparing for this video and kind of scripting out what I was going to talk about, like I said, I got a message from Hannah Hill over at the National Foundation for Gun Rights. And apparently the Fifth Circuit, well, they've seen enough. And they have issued a very brief ruling. Because the ruling of the Fifth Circuit reads as follows. It is ordered that the opposed motion of the states to intervene as defendants' appellants is denied. Movements may seek participation as amici. So like I said, the Fifth Circuit is having nothing to do with it. This is an incredibly lame and last-minute attempt by these attorney generals to intervene here to try to muck up the waters because apparently they believe that their interests are no longer represented. I can assure you that this will be not the last time that we see this. This is likely a tactic that's going to be used by many of these blue states, all of which has one design in mind, and that is to undermine any of the new administration's policies as it relates to our Second Amendment rights. Listen, we're going to go ahead and link up everything that we talked about down below so that you guys can geek out on it for it. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. You guys should know how to get a hold of Washington gun law by now, but if you don't, oh, it's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you just click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From Guns and Gear right here in beautiful Idaho Falls. Thanks for watching and stay safe.